For the first session. Thank you very much. I see Deborah Long, I see Rachel, Marie, yes, so I think we have our speakers here, Lizzie, and also Sila, yes. So everyone, I think we are just drifting back from the short break, but welcome. This is a Friday afternoon for some of us and Friday morning for others. And we really appreciate those of you who are still with us since the morning, early start. And we welcome you back for this, the last session of our conference today on 40 years of the African Charter on Human and People's Rights, remembering also the role our beloved friend, colleague, mentor, colleague in many ways for many people across the globe, Professor Heyns, had also played in the growth and evolution of the system. This session is a bit diverse, but I think it ties itself together around the theme of the reverberation, the kind of broadening of the effect of the African Charter, the Commission and Court's work. So we have a session that composed of 4 papers, as you will see from the program. We will look at the normative influence, the normative echoes, if you like, that the African system has caused. We will look at the post-judgment phase, looking at what happens after the decision, specifically the recommendations of the African Commission, how are those being dealt with. We're looking at the public life of the African Court, and then lastly, the kind of reverberations into the future, looking at reform, possibilities of reform. I think that's a topical and a good place to end us off. The first paper, and we welcome Professor Abiora Okafor and Godwin Za. I remind us all that we have 15 minutes, more or less, and that includes those who are in pairs. So it does not extend the time. And we ask you to keep relatively slow in your speed of delivery, since this is being interpreted. The interpreters are doing the French for us. So we welcome you. And let me briefly say about Professor Okafor that I think he needs very little introduction to people who follow the African human rights environment. But I think for me, he's most famous for his book, The African Human Rights System, Activist Forces and International Institutions, that had really become a very standard work for anyone engaging with the system and understanding its dynamics. He is presently holding a chair in international and transnational legal studies at the Osgood Hall Law School in York, at York University, Toronto, Canada. He has published widely, and I thought, you know, this is for those of us who are in the afternoon, I brought some props. So I have here my favorite article by Professor Okafor and his colleague, Ugochukwu, and that is, have the norms and jurisprudence of the African human rights system been pro-poor? And since we are also celebrating Christoph's work in the African Human Rights Law Journal, and since the papers presented here will hopefully find their way to the African Human Rights Law Journal, I just also highlight this aspect of Professor Okafor's work, the article that had been published in the African Human Rights Law Journal earlier in 2011. So thank you very much for agreeing and being with us this afternoon, Professor Okafor. He is with his colleague Godwin Za. Godwin is a doctoral student at the Peter Allard School of Law at the University of British Columbia, also in Canada. And his research explores the interaction of natural resources, environment, and society within the context of North-South engagement. He hails from Ghana, where he did a baccalaureate in law. He was admitted to legal practice, and thereafter also completed a master's in law at Harvard Law School. So thank you very much to both of you. The title of the paper is The African Human Rights System as a Norm Leader, 3 case studies. The floor is yours. The virtual floor is yours. Thank you.
Thank you so much, Professor Viren. I hope I'm pronouncing it very well. I live in Canada, where my name is never pronounced well, but we go with the Canadian version, so I'm very sensitive to that. It's a pleasure to see you in person, in a sense. I don't want to get into your sort of pioneering, excellent leadership in this field because we don't have too much time. Just to quickly lead off with saying that I'm here today, and I really made a point of being here with some sadness, of course, because of whom the conference is dedicated to, who I had met in Toronto, actually, at the conference, and was really sad to learn of his sudden passing. But it's also an honor to be able to give this paper in a conference that is honoring him. I just wanted to say that. So the paper is with my colleague, the now newly minted Dr. Zah, and he'll do most of the presenting. I'm just going to spend another maybe 4 minutes just laying out introducing the paper and laying out theoretical framework in very little time that I have, so that he can have maybe another 11 minutes or so to develop the rest of the presentation. So what we essentially argue here is that the African system has functioned as a type of norm leader that has made critical, even radical contributions in particular specific areas to the global human rights project, that its praxis has been quite remarkable in those aspects, and that it has helped shape developments beyond the system, diffusion beyond the continent to other systems, to other states, and so on. The paper is still very much a work in progress. We have to produce it in a relatively short time. So we will continue to rework it post this presentation today. The paper the paper is sort of within the broad idiom of a critical tradition of international law on the continent, and one that is defined by studying how contribution is done, but contribution through resistance. And that's sort of the frame with which we see these particular contributions of the African system. It resisted a particular mainstream orthodoxy while enriching and enlarging the global body of norms. Now, in order to sort of tease out our points, we draw, although we're not bound to, but we draw from social constructivist theory, in particular strategic social constructivism, and even more specifically, norm life cycle theory in the human rights context. And we don't have time to develop that, but essentially constructivism is sociological theory in national relations or world politics, emphasizing the power of ideas and how it diffuses and is taken up by others, to put that sort of simply. And I just want to quickly refer to Martha Finnimore and Catherine Sickling's a short quote from their work, where they describe the norm life cycle, which is made up of 3 stages: norm emergence, where there's persuasion by what they refer to as norm entrepreneurs, who then attempt to convince a critical mass of states who are norm leaders. And I'll get back to this in a second, because here they're referring to states to embrace new norms. And then there's then a cascade where the norm leaders attempt to socialize their peers, who again, in their theory, are states, right? All right, so they attempt in this way to systematically explain how norms are sort of proposed, diffused, and internalized. We hook onto just one aspect of this, which is norm leadership. And here, what we do is we repurpose their conception of non-leadership and attempt to modify to include and encompass international bodies or regional bodies like the African system, and say that their theory actually accommodates it. So we're not opposed to their theory, we're just saying that their theory accommodates what we argue that the African system has done already and continues to do, which really is that it has, in some respects, in particular respects that we explore, thrown an invitation to others, actively thrown an invitation to other systems, states, other actors in the international order to mimic its Africanist human rights ideas that are rooted in broadly speaking African conceptions of human rights, and that it has to an extent been successful. That's what we argue, modestly, but yet quite significant in this context, in modifying, again, not just particular provisions of human rights, but the conception, the inherent sort of immanency of the conception of what human rights are and what human rights are not. That's what we're trying to get at. And we say that it has driven, following seeking, a dynamic of imitation, right? A dynamic of imitation of things like people's rights, of things like the right to the environment, of remedial secession, the right to development. And these are just examples that we use. And we end up pointing out the limits of its non-leadership and areas where it could push further, but has so far not really pushed into. And I'll now hand over to Godwin to add some flesh. Apologies to vegetarians to this framework or outline.
Thank you, Professor Kafo, and good morning, good afternoon, good evening to everybody. So I would just speak briefly about three aspects of our paper, and focusing more specifically on the three norms that we've chosen as an entry point into discussing this strategic social constructivist theory and how it interrelates with the African human rights system, and then move over into talking about when we look at the way this particular theory functions, as Professor Kafo laid out, we are looking at it in terms of how these three entry points not only inform the specific rights that we are talking about, but how they sort of disperse and go beyond the African human rights framework and influence international developments, and then comes back again to influence the way African norm development happens. So that's what we talk about, the life cycle of norms. Now, when we look at the three that he just introduced, the right to secession, or what we generally call remedial secession, and right to development, and also the right to environment, we see them to be part of the broader African regional human rights system as a vision, but then we push further to say that these three, together with all the other rights in the African Charter, establish what we generally will refer to as the human rights rule-based order. So in a sense, with the establishment of this African human rights system predominantly based on the African Charter, we are transitioned from what had been a visionary process all through the during the colonial and much of the post-colonial life of a lot of African states, to establishing a more concrete, actionable system. So when we talk about it in that manner as a rule-based order, we are talking about norms and we are talking about institutions. And in terms of norms, I'll discuss a bit about that, but just to lay the groundwork on the question of institutions. We argue that when you look at the way the norms function, they function within the context of these institutional frameworks. And so there's a complementary relationship between norm development itself and the institutional framework that produces those norms, that implements those norms, that reforms those norms. So those institutional frameworks, we largely would limit ourselves to the African Commission and the African Court. And in that regard, we also argue that when it comes to the way the norms function, they are largely a product of African conceptions and African worldviews on what human rights should look like or what human rights should be. So it is not necessarily a continuation of the orthodoxy of human rights that had predated 1981, but it has a more prospective, future-looking Afrocentric vision. And when we look at the three rights that we are talking about, the reason we chose them is because we look at the way the African human rights system is set up. One of its definitive features, one of its distinguishing features is the concept of people's rights. But then we also argue that before we even talk about the concept of people's rights, we have to actually unpack the language of concept of peoples to sort of understand the multi-layered nature in which the conception of peoples influences and implicates these rights. And so we speak about them in terms of how they make an original contribution to the human rights framework, more particularly the way these people's rights creates norm leadership in terms of Africa's participation in the global praxis of human rights, and also the way that these particular rights or norms are evolving as we see through the literature and also as we see through activism on the African continent and also beyond. So because of our time constraints, we will take highlights of the three norms to sort of create this broad picture that will set the tone for further discussion. So when we look at the remedial secession, we know that there are all kinds of contending ideas about how international legal system does not necessarily, speak for or against remedial secession. But then, at least if we look at the common Article 1 of the International Covenant for Civil and Political Rights, and also the economic and social and cultural rights, we tend to see that there is this recognition of a right to self-determination. And this is galvanized also in the UN Charter. But for us, we are concerned more about how Article 20 of the African Charter interacts with these particular normative development. And we see that the real concern for African countries, interestingly, while it was a question of establishing control and sovereignty in the post-colonial period, was much about maintaining the colonially bequeathed borders. So it's a very interesting thing to see how states that ordinarily have been separated actually agree to have maintained those borders. And we would refer our panelists and our colleagues to look at some of the works by radical African writers like Professor Okafor on the subject and Professor Makau Mutua, who've spoken about how we can really look at how to redraw the borders of Africa. But for us, our concern is that when we begin to look at the African human rights jurisprudence, beginning with the Katanga case, for example, we see that the African human rights system speaks to this particular topic in a way that says, if there are egregious, gross human rights violations that happen within the territorial integrity or territorial confines of the state, and which would not help or which militate against the progressive nature of state participation, democratic participation, then we would see that there has been a right that has been established to secession. Now, that particular development, we need to be able to give recognition to the role that NGOs, the role that non-state actors play in the evolution of this particular idea. And we see that beyond that particular case, we go to the Sudan Darfur case. We see the African human rights system through the African Commission speaking more authoritatively on this subject, sort of making a conditional affirmation that when we look at a situation where there's internal or external abuse, the right to secession may kick in. So in that sense, we see a refinement of this particular Article 20 jurisprudence. So at this point in time, the conception that it would be more of a question of external aggression is defeated because the African human rights system welcomes internal disintegration as well if there is evidence of extreme abuse internally. Now, what is remarkable is that when we look at the way this particular jurisprudence functions, it predates or it goes well in advance of what we see, for example, in the Canadian Quebec reference case, which draws on this particular jurisprudence. So even though the literature does not say so much about it, when we start unpacking what those developments have been since the Canadian reference, you begin to see the influence of the African system. Now, with regards to Article 22, which is on the right to development, it also flows from this particular understanding of the norm leadership of African human rights system. But more particularly, we understand the history through the colonial and post-colonial struggles of the global South broadly. We just want to limit ourselves to a few cases. So we look at the Bakweri case in Cameroon, we get to understand that the real concern for African states was that if we could use the same system, this human rights system, to ground a right, for example, the right to development, we have to think of it in a more elastic and pliable manner. And this was one of the reasons in the Endorois case, for example, while it was largely a question of the protection of ancestral land or access to ancestral land, we begin to see the African Commission speaking more authoritatively on the right to development. So we see the connections that we saw earlier on being established in the first norm on secession being sort of given life in the question of development, in a more subtle way, but also in a very forceful manner. And this proceeds to the more recent case of the Ogiek decision in the African Court, which emphasizes this particular concern. And in the Ogiek case, one of the key things that we often miss out is that in its decision, the African Court was actually emphasizing the work of the UN, the philosophical basis of the United Nations Declaration on the Rights of Indigenous People. So it was this particular case that gave this broader global significance to UNDRIP. But much of that discussion is sort of lost in the context of looking at the Ogiek case only. And the final point, we have just 1 minute to go. The final point on the question of the environment, we see also that Article 24 begins to push the borders of the human rights jurisprudence in the context of the environment beyond Africa, informing the amendment of the American Commission's work and also the promulgation of the adoption of the Arab Charter on Human Rights. Now, the two quick submissions that we want to make are that when we look at the developments we're talking about, we see a lot of shortfall happening in two contexts, LGBT and sexual orientation rights, and also in relation to corporate criminal liability in Africa. While the African context has helped to engender some discussion on this, we see a lot of limitations also in that space. So I'll just turn over to Professor Kafo to finish up.
I think we'll just leave it at that. Just except to reemphasize that one of the things that we hope to do post this is to more deeply interconnect the analysis in the substantive part that Dr. has just outlined with the theoretical framework that guides. Well, I mean, we attempt that in the paper itself, but we need to weave that more intensively together. And I'll just leave it at that. And I thank you for your attention.
Thank you. Thank you. I listened very intently, and I'm sure so did our audience. I invite everyone to still make remarks, comments, or pose questions. I see there are some questions for Professor Okafor, for example, in the chat box. We can answer this in the chat box, and we can also hopefully have a little bit of time at the end. But if you would also check the chat box, the question and answers box as the speaker, we ask the audience to post their comments and questions there, and please do this continuously. So we move on to our next speakers. Again, we have a group of two. Most welcome to Professor Rachel Murray and to Deborah Long. They are good friends of the center, of me personally, but Professor Murray is, as I think many of us know, Professor of International Human Rights Law at Bristol University, and Deborah Long is a Senior Research Fellow at the same university at the School of Law. They are both very interested and work with the Human Rights Law Implementation Center, which has been engaged in a project around looking at the implementation of decisions, findings across various regions. We at the Center for Human Rights here at the University of Pretoria have been privileged to work with Deborah and Rachel on this project. I think some of what they will talk about also feeds off that particular project. They also share an interest. They have published around issues of persons deprived of liberty, specifically around prevention and prohibition of torture. So I promise that I'll have props. I have a prop again, and this is a joint publication that I think many of us may be aware of, implementation of the findings of the African Commission on Human and People's Rights by the two of them, co-authored. It's a seminal work in the area of the implementation of the Commission's work. Therefore, we can ask for nothing better than to listen to them speaking about the monitoring, the implementation of its own decisions, the role of the African Commission on Human and People's Rights. Please, the floor is yours, Rachel and Deborah. Debbie.
Thank you so much, Franz, for that very kind introduction, and it's a real honour to be able to present here today. Debbie is going to start and do the first part of our paper, and then she'll hand back to me. So I'll hand over to Debbie.
Okay, thank you. And yeah, firstly, I'd like to thank the organisers of this event and the opportunity for Rachel and myself to speak at this very important conference. Our presentation, as Franz mentioned, is going to look at the role of the African Commission, what it does and could play in respect of monitoring implementation of its decisions on individual communications, and also offers some ideas for further reflection and discussion. So I'm going to present first a summary of what the African Commission has done so far to consider its role and the procedures in place, before handing over to Rachel, who will speak more about some of the challenges and opportunities in more detail. As Franz kindly mentioned, our presentation is based largely on the findings of a 4-year research project which examined implementation of decisions on individual communications. In that project, we looked at all of the regional human rights bodies, as well as the UN treaty bodies too. We would particularly like to acknowledge the insights and advice Professor Heyns provided during our implementation project, and his significant publications on the relationship between impact, implementation and compliance. So I think maybe to explain firstly, well, what do we mean by implementation? We consider it to be the process by which states take measures at the national level to address issues of concern raised by the human rights treaty bodies. Typically, this is a legal process, so to incorporate them into domestic law through, for example, law, judicial decision, executive decree, or some other legal process. Now, in recent years, I'm sure all of you have noticed there has been a growing interest in examining the extent to which states implement decisions or judgments from supranational human rights bodies, including the African Commission, partly in response to what has been described as an implementation crisis. Now, of course, states bear the primary responsibility to provide redress and reparation to victims of human rights violations. However, it is recognised that supranational bodies, such as the African Commission, do have a very important role to play in monitoring implementation of their own decisions, and that they can incentivise, facilitate, and trigger implementation through a variety of means. Indeed, the African Commission has been willing to take on a monitoring role, as illustrated not only by its procedures it has set up specifically to follow up on its decisions, but also through the use of other procedures and mechanisms. Some recent developments include the newly revised rules of procedures, which now explicitly set out the follow-up procedure for its decisions, requiring information from states within certain set time periods. The working group on communications also now has an express power and duty to coordinate follow-up activity, although it is acknowledged that there are considerable challenges for the follow-up procedure to be effective. Furthermore, as well as prescribing the follow-up procedure in its rules of procedure and the mandate of the working group on communications, the African Commission has, over the years, used a range of other mechanisms to gather information on implementation of decisions. In fact, the African Commission is uniquely placed, as it has a broad range of procedures and mechanisms it can use to monitor implementation of its decisions, although in practice these are underutilised. For example, we've seen in some instances the state reporting mechanism under Article 62 has been used to follow up on decisions. A few states have used their periodic state party reports to inform the African Commission on the measures they have taken to implement a decision, but the dialogue with the Commission has also enabled questions to be asked of the status of implementation in a few instances. Also, occasionally, the African Commission has even included in its decisions an express recommendation for the state to provide information on implementation in its next periodic report. Similarly, in a few instances, the Commission has used its missions to states as an opportunity to ask questions and gather information on any measures taken to implement its decisions. So the African Commission has appeared to be receptive to also developing other measures to focus on implementation of its decisions, although it has to be acknowledged that such measures are exceptional. For example, even back in 1995, before the follow-up decisions was expressly provided for in rules of procedures, the African Commission did use an extraordinary session to focus principally on follow-up on a number of communications involving the government of Nigeria. More recently, mirroring the approach of the Inter-American Court of Human Rights, the African Commission has also held 2 implementation hearings at the request of complainants. This has been used as a means to gather information and to try and foster a dialogue with the state. One of these implementation hearings was in respect of a series of cases against Mauritania and the other against Kenya. Also in recent years, the African Commission has reflected further on its role in monitoring implementation and trying to take stock of its current procedures and to learn from a broad range of stakeholders what perhaps it could also do to strengthen those follow-up procedures. These consultations were held in 2017 and in 2018 as regional seminars, the first in Dakar and the second in Zanzibar. Now, these regional consultations brought together the African Commission with members from states, from national human rights institutions, as well as civil society, as I said, to try and take stock and address ways to try and strengthen the system further. Now, the outcome of these discussions does provide some useful and practical ideas for further reflection. For example, one of the recommendations was to establish an implementation unit within the African Commission Secretariat. This would provide necessary support to the working group on communications and also a vital focal point to request information from states, complainants, as well as other stakeholders on measures taken to implement decisions. Similarly, a further recommendation was made to develop a database with up-to-date information on the status of implementation of decisions by states parties. Other examples or recommendations from these consultations were also aimed at trying to increase visibility, for example, by developing a communication strategy, taking into account the special relationships between the Commission, state parties, national human rights institutions, and civil societies, and to try and collaborate with all stakeholders, including national human rights institutions, in disseminating recommendations and decisions of the Commission. And perhaps it's time to review the outcomes of these regional consultations again, and to consider some further actions to be taken in respect to some of the recommendations that were made. Therefore, there are, I think, various opportunities and precedents for the African Commission to use its range of procedures and mechanisms to strengthen follow-up on its decisions. I'm going to now hand over to Rachel to discuss some of these issues in more detail.
Thanks very much, Debbie. I'm going to focus on sort of defining and a clearer role in respect of the African Commission in monitoring its own decisions. And actually, when we did our implementation project that's been referred to, the importance of a treaty body and supranational human rights bodies having a clear strategic role in monitoring the implementation of their decisions was a point made very eloquently to us by Professor Heyns. And I think if you look at the implementation dynamic between states and complainants, it's recognised that supranational bodies such as the Commission have a key part to play in incentivising, facilitating and triggering implementation. And in fact, they can undertake a variety of different types of roles in doing so, whether it's simply gathering information, reporting on measures that states have taken, engaging in dialogue, interpreting and technical assistance, assessing whether states have complied, coordinating activities, or indeed enforcement. The sort of softer forms of interaction, the dialogue, a sort of managerial approach to compliance may be effective in certain circumstances, but full implementation takes time, and the ability to maintain this dialogue over a sustained period is also important. But it's also recognised that dialogue may run its course, these sort of softer forms of interaction and encouraging compliance may not be effective in certain situations, and the ability to move to less persuasive and more forceful measures may be needed. And I think what we can see from the approach of the African Commission is that it tends to adopt a more persuasive approach, focused principally on gathering information, most of which can be kept internally, and then reporting on measures that the state's taken to implement the decision. In some instances, it's offered a space for dialogue. I think we can see that in relation to the very small number of implementation hearings, and indeed it's referred to the aim of those being as forging dialogue and strategizing with the government and civil society. But it doesn't appear to have been willing to push it much further and take on a role of enforcer. And where information has been published on the measures that states have taken or failed to take, that can be rather limited. And similarly, where the Commission could refer cases onto the court or to the political organs of the AU, then these processes have similarly been rarely utilised. And I think this can be explained in a number of ways. Firstly, the degree of discretion given to states and leeway given to them. For example, in adherence to deadlines for submission of information, it's not clear what the Commission does in relation to states who fail to comply. Secondly, in relation to the specificity given in decisions and in determining the reparations that should be provided. Specificity here, I think, can mean different things. It can mean how much detail is provided in the content, the reparation, whether specific deadlines are set, whether the treaty body defines which state authorities are responsible for implementing. And I think it's clear that the Commission's decisions have shown increased sophistication and specificity in terms of the content of the reparations, but less so in terms of deadlines or specifying which state authority might be required to implement specific aspects of the decision. Secondly, there is an issue around assessing implementation, and we recognise this is not straightforward. And this is a point that was made again by Professor Heyns in his publication with Franz on impact of UN treaty bodies around the causal link between a decision from a supranational treaty body and the subsequent behaviour of the state. It's not always easy to make that connection and to show the sort of influence of an international body on what happens on the ground. And so consequently, sometimes statistics on the low level of compliance by states with supranational bodies can mask some of those issues and mask some of the challenges. And we've seen the Commission has been willing to gather information, but it seems to be much less willing, and maybe because of the paucity of that information, to make any assessment on the extent to which those measures are appropriate or fulfill what is required. And some of that information, certainly the detailed information on what states have done, is not always made visible. And neither has there been any criteria for how the Commission might determine whether those measures are sufficient or not. And this just relates to final sort of substantive point I want to make, which is around visibility of the measures that states have taken. We've seen that supranational bodies use publicity as a way of sort of naming and shaming states to try and prompt implementation. And the Commission has experimented in this too. Its working group on communications presents reports, as Debbie has mentioned. But again, the level of detail on what measures states have taken or where they may have been wanting in some respects is rather limited, or it's simply not made public. There are limited occasions where the Commission has referred cases to the court, but none around non-implementation of its decisions, some around non-implementation of provisional measures. And referral to policy organs of the AU is a possibility within its rules of procedure. There are challenges there with the risk of interference by those policy organs in the independence of the Commission and its decisions, but that capacity is still there. So to conclude, I think, as Debbie has outlined, the Commission has clearly done a lot to focus on implementation and monitoring its decisions over the last few years. And looking in the round, it's used all aspects of its mandate to try to monitor what states are doing. It's attempted to think about this strategically, in particular through the seminars in Dakar and Zanzibar, and come out with some very practical recommendations. But I think there is a risk that the momentum that these extremely important initiatives have started needs to be sustained. There's a risk that it will be lost. And some of these very useful recommendations and proposals, such as developing guidelines with indicators to assist in monitoring decisions and a database, we hope that we will see those come to fruition. I think the rather what appears on the face of it inconsistent approach could be avoided if the African Commission could clarify its role as in terms of monitoring, whether it's at what stages it will offer dialogue, what stages it may push to become more of an enforcer in monitoring its decisions. And we note that a nuanced sort of comprehension to appreciate at what stages one moves from dialogue to something a little bit more forceful can assist in improving implementation of these decisions. Thank you very much.
Thank you very much, Rachel and Debbie, for sharing those insights, and I think very, very pointed recommendations. I think the broader context in which we seem to find ourselves continuously is that of reform and adjusting the system to the demands. And thanks for also showing the trajectory of how implementation had been taken progressively more seriously by the Commission, but pointing out that that's not a given. It's always a work in progress. Rachel, you mentioned the work that Christoph did on impact, and permit me then to have another prop here. So clearly this is the book, right? The book on impact. So we remember Christoph really linking to the theme that you also brought out, implementation, linking to the much broader concept of impact. And in the years before Christoph's passing, Rachel became part of the team, and we are working on a reissue, if you like, a new updated version of that study of 20 countries. And we will bring this to fruition in the near future, and still remember Christoph, obviously, and his contributions to that particular endeavor. Well, we had experience, and I think now we go to youth. We have Lizzie Mutoni Kibira, who is finishing her studies at the Strathmore University, Nairobi, Kenya. She has been involved in a number of capacities with Strathmore University Press, for example, as editor and also as administrative assistant. She's been working in various capacities in the law school more broadly, the Strathmore Law Clinic, and she has also been with us here in the center for the Keba Mbai conference on looking at African approaches to international law. That is way back already in 2018, and she presented a paper looking at the dialectics and recognition in African approaches to international law. So she clearly is someone who's been thinking deeply and very interestingly about issues pertaining also to the African regional human rights system. We welcome her. We thank her very much for being with us today, Lizzie, and she will speak on the public life of the African court through the lenses of the Ogiek case. Over to you. Thank you so much.
I am so beyond honored to be here today, and it's once again really wonderful to see you, Professor. And unfortunately, I never got the chance to meet Professor Heyns in person, but I will just give one little story before I run out of time. Last year, I was training a few of my friends, helping them with the African court moot. And one of the problems that was part of the issues was a question of assemblies, yes, assemblies and policing assemblies. And I remember telling them, when you go speak to these people, they want you to learn. They want you to engage with them. And Professor Heyns wrote the general comment regarding the policing of assemblies. And when this young man went and engaged with him, they told me later about how they were impressed by how accommodating he was. And it was a very, very beautiful experience for me. And it's such an honor to be presenting at something in his honor and in his memory. And I hope I will just Yeah. So my presentation today is about the public life of the African Court of Human Rights. If I could just share my screen. So yes, there is my presentation. I'm hoping it's visible to everyone. So the title of my presentation is Mahakama ya Kimataifa ya Bara Afrika. And it is intentionally in Swahili to already foreground the questions of translation and to whom are we addressing the African Court of Human Rights. And this is not my own translation. It is a translation I picked from a news item that ran only a month ago in May, and it was a report regarding the implementation of the decision of the court in 2017 that up to now has yet to be enforced, and the Ogiek people have been suffering evictions over and over again. So during this report, this is how the Swahili news reporter describes the court, Mahakama ya Kimataifa ya Bara Afrika. And off the bat, you can see Mahakama means court in just regular Swahili, Kimataifa, international, but also it has connotations of being superior because it is international. Bara Afrika simply translates to African, as in the continent of Africa. So on this 40th anniversary of the African Charter, it would, my reflection centers on the African Court because I think, and as it was discussed earlier, it is indeed the jewel of the Charter. And as was highlighted earlier in the keynote addresses, some would have had it come earlier, but here it is finally after so many years. And it is very interesting that to have the Charter. I was born when the Charter was only something of 20 years old. And I was born the year prior to the adoption of the protocol for the establishment of the court. So it is something that has been very much in our lives, quite literally. And so the question becomes, if we're going to look back on the work of the Charter, on its contributions to the African continent, to the human rights discourse, how about we look at it through the court, the pinnacle of the entrenchment of the system within the African system? If we look at the work of the court, what can it tell us about the success of the system as a whole and the success of the Charter as an instrument? So how do you measure an international court? It has been, well, it has been the subject of a lot of discussion for a long time. And I think I identified just a few of the major aspects that people have identified. Effectiveness, which actually I think have come out during the discussions today. The question of effectiveness, and bouncing off of the discussions by Deborah and Rachel just a few seconds ago, the question of effectiveness and implementation comes into play. Systematization, as was the focus of Apolline's presentation earlier in the morning about the systematization of the African Court to relate to the African Commission, to relate to other executive branches in the AU system, as well as the global human rights system. And the last one, legitimacy. Another very tricky one. Legitimacy in international law is a whole story because, again, is international even law? Yeah, but so the question of the legitimacy of international courts, big question. And Amin von Bogdandi and Igor Vansky, in their recent publication called In Whose Authority, have brought about this question of public authority, because more and more international affairs are becoming the matter of everyday life. While the public was previously excluded from international law, now our everyday lives are very much regulated by international laws, be they human rights laws or in the form of norms, recalling the discussions of Professor Okafor, in the form of, and actually, yeah, from the work of Mother Finemore and I forget the other author, but the norms, and that is most apparent in this period we live in right now, because the WHO now gets to tell us how we sneeze and how we use sanitation. And so the international law systems have become more and more a part of everyday life. So how do we measure the international court though? When we go to the publicity part of it, that's one of the things that marks the uniqueness of the international court versus, say, the African Commission. The Commission and the court do the decisions, for instance, the judicial aspect of it, they do very much a lot of the same work. Technically, the reasoning, the jurisprudence does not differ so much. But what distinguishes it? One of those aspects is the publicity of it. The International Court is an international court. But I think that is an aspect that tends to get lost in our discussions. What does it mean to be a court? And more so, what does it mean to be a court to the general public? And the reason why it is important to consider the general public in our discussion of the success of the Charter is, again, I go back to this quote that we have all been talking about today, and it's from Professor Heyns' 2001 paper. And he says the ultimate test for any legal system that purports to deal with human rights is the difference it makes to the lives of people. So human rights fundamentally foregrounds people and their lives. But how does human rights treat the people? Human rights is fundamentally for the people. The general public appears in human rights as a subject that is typically a victim, a la CVS Makau Mutua's argument, a victim in need of protection and empowerment. And in the image you see on your screen, there is an image that I took from a news item about the non-enforcement of the Ogiek case and the persons who are suffering from it. And this is the typical image of human rights discourse, the image of people in suffering, in need of protection and in need of empowerment. But is that all there is to the people in human rights discourse? Is that all there is to how we think about the general public? And for this, I look at the Ogiek case and the divergence in the divergence in how the Ogiek case was talked about in general public discourse. And for this, I just sampled about a lot of media reports, and a lot of it is also drawn from my own personal experiences with the case and other people with whom we went to school with, and just members of the public. In public discourse, it was talked about the question of a victory, a win for the Ogiek people. Finally, the court orders would be enforced and they would be able to go back to their home. In legal discourse, however, it was a question of a landmark. It marked the point in a long story about so many other things, and it becomes a question of indigenous people's rights as a concept, and then it becomes a question of conceptual developments. And we've seen this even today because the Ogiek case has come up several times. For example, when Professor Okafor spoke about the Ogiek case, the Ogiek case discussion on the right to development. That was another instance of how in legal discourse, it's a conceptual development question. But again, in the public discourse, the big thing about it was a question of victory, power. They had won something. The landmark just falls out of it. It only appears it becomes foregrounded in legal discourse, but not in the public discourse. And then this creature called the African court suddenly appears in Kenyan popular discourse, which had not been very prominent before. And so, for instance, you have, these are a few news headlines about the same time the Ogiek case was decided.
Lizzie, I think we have difficulty in the connection for the moment.
The second, the nation, and the third is the emphasis on power and the court. Oh, am I back?
Yes, please continue. There was just a slight moment. Please continue.
Oh, okay. Sorry. If I could just go back a bit, my emphasis was on this creature that appears in the public discourse called the African court. And as I was saying, the nuanced discussion that will happen and have happened today, for instance, about the complexities of the systems and how the relationship of the African court and the commission, and should that relationship even continue, should it merge, all those kinds of nuances get lost in public discourse. And when you hear African courts, it takes us back to that headline, Mahakama, court. What does a court do? It gives you, it's a form of power. It gives you judgments that are enforceable, that change the way things work in your world. What does it mean that it's African? It means that it is the highest in the land. So we find this prevalence of African court. And it's not either the function of it's not a coordinated function of either the institution itself, those involved in legal discourse, or the public. It's not a concerted effort, but it just emerges on its own. And I would argue that to mark the prevalence of this kind of public presence, when it gets to the tabloids, you have, well, made it. And so you have here a very interesting tabloid that reads, "Drama as angry Ogiek community demands resettlement in Mao as ordered by African court." Again, the nuance completely dies. And that is because the African court it's a very simple signifier in general public discourse. So why is it important for us to talk about how the court exists in the public life and the public life of it? And here I have a quote from this English scholar, Peter Goodrich. And he says, "Law is best when, that is to say most effective, when it does not have to be stated, if it can simply be present, if it inheres through signs, through visible manifestations, a monumental social presence and public array through text and rather than through text and detail." One of the questions we have been having about what is the success of the court and therefore of the charter is that question of what does it do for the public? But if it is an institution that is to stay and be with us for a long time, it needs not only do something for the public, but it needs to be part of the public's life. And in my opinion, it would also go a long way into influencing the question of implementation. The moment that court becomes a part of the public life of the public life of the general publics in Africa, that means we are all invested in its success. For now, it remains the African court, at most when it comes closer to home in Arusha, but then at the same time, it's still a mystery. It's still unknown to us and in its capacities and in what it can do. All we know is all the public heard on the 26th of May, 2017, was that a group of people had won a case at an international court that ordered the Kenyan state to give them their land back. It is rather striking to a general member of the public that 4 years later, none of that has happened, yet it is the International Court of Human Rights, the African court, the highest court in Africa, that ordered this. Therefore, that merging of the public's understanding of the court and the court's own self-representation is a necessity. Yeah. If I am within my time.
Yeah, you can just conclude in a minute or so. Thanks.
Yes. So in conclusion, the point of this research arose from this the question of the divergence, and the impetus for it was to understand how do we in the legal discourse relate to the general public. Is it possible for us to to revert the gaze, instead of them being our subjects, our subject of discussion, but to see the public as the subject, to see ourselves from their eyes, and from their eyes we're completely unknowable at the moment, but look like a court that, well, can deliver a decision, and 4 years later, here we are. Thank you.
Thank you very much, Lizzie, for that. I think that, you know, you even, I think, brought some themes that came out in the early morning when Commissioner Darso also spoke about the broader legitimacy, the perceptions, the visibility, the meaningfulness of the court in the eyes of our people, the broader African population. So I think you gave a very broad brushstroke that certainly enriched our. Yes. Maintenant, Monsieur Abdoulaye Sylla, vous m'écoutez?
Oui, je vous entends bien.
Ok, merci, merci. Soyez le bienvenu. Vous êtes notre dernier intervenant. Monsieur Silla il est juste devenu docteur en droit public à l'université Paris-Nanterre. Il avait fait des études de baccalauréat et maîtrise à l'université de Sonfonia Conakry au Guinée. Et il est aussi assisté aux cours et il a fait un master à l'Institut de droits de l'homme de Lyon et à l'université Pierre Mendès France de Grenoble. Il a fait beaucoup de publications et nous sommes fiers qu'il a publié dans l'annuaire africain des droits de l'homme de l'année passée. Et cet annuaire est une publication qui est dirigée ici au Centre des droits de l'homme, mais c'est une collaboration entre la Commission et la Cour africaine des droits de l'homme et des peuples et le comité sur le bien-être et les droits de l'enfant. Merci beaucoup, Monsieur Silla. Veuillez parler lentement, s'il vous plaît, et vous avez 15 minutes pour la présentation. Merci.
Merci beaucoup. D'abord, je commence par vous remercier pour l'invitation et pour cette présentation que vous venez de faire sur ma modeste personne. Moi, j'interviens sur les réformes de la Cour africaine des droits de l'homme et des peuples. En fait, je suis le président de la section africaine des jeunes de l'Académie africaine de la pratique du droit international. On a organisé une conférence sur les rapports de la Cour africaine avec les autres cours régionales. Et lors des débats, il y a un ancien juge de la Cour qui a émis le souhait de ne pas voir les deux protocoles de 2008 et de 2014 entrer en vigueur. Donc, il a exprimé une inquiétude au sujet de ces deux protocoles. Et c'est ainsi que j'ai eu l'idée de travailler alors sur les différentes réformes-là pour voir ce que ça apporte comme impact sur les droits de l'homme. En effet, l'Afrique est souvent indexée en matière de violation des droits humains. Pourtant, l'Organisation de l'Unité africaine, OIA, s'en était très tôt préoccupée en précisant que la liberté, l'égalité, la justice et la dignité sont des objectifs essentiels à la réalisation des aspirations légitimes des peuples africains. L'Afrique, à l'instar des autres continents, a prévu deux types de protection. D'un côté, la protection juridique, de l'autre côté, la protection juridictionnelle. La protection juridique devait passer par l'adoption d'un ensemble d'instruments juridiques qui consacrent les droits humains sur le continent. Et la Charte africaine en est le pivot. La protection juridictionnelle, quant à elle, est la conséquence de la protection juridique, parce que la protection juridictionnelle de ces droits renvoie à l'ensemble des juridictions et aux mécanismes quasi-juridictionnels qui veillent au respect des droits et libertés juridiquement reconnus ou consacrés en sanctionnant leur violation. Donc, la protection juridique étant insuffisante et inefficace sans la protection juridictionnelle, les États africains ont pensé, les rédacteurs de la Charte ont pensé à mettre en place un mécanisme de protection. Mais lors de l'écriture de la Charte, il y a eu plusieurs propositions de débats houleux autour de ce mécanisme-là. Certains voulaient qu'on crée plusieurs commissions au sein de l'OIA, dont une aurait pour vocation le contrôle de la Charte. D'autres avaient émis l'idée de créer une Cour africaine depuis 1961. Donc finalement, c'est la commission qui a été créée par la Charte africaine des droits de l'homme. Mais la limite matricielle de cette commission réside dans le fait que ces décisions ne sont pas obligatoires. Ces recommandations ne sont pas obligatoires. Pour corriger cette lacune et rigidifier le contrôle de la Charte en vue d'une meilleure protection des droits humains, il a été envisagé de créer la Cour africaine africaine des droits de l'homme. Toutefois, la création de la Cour a rencontré et rencontre encore de nombreux obstacles. Certains États sont sceptiques à son égard, tandis que d'autres la voient comme une menace contre leur souveraineté. D'ailleurs, ceux-ci considèrent le concept des droits de l'homme comme un héritage de la domination coloniale, raison pour laquelle l'institutionnalisation d'une Cour chargée de contrôler la Charte africaine des droits de l'homme n'a pas vu le jour en 1981. Le contentieux des droits humains, selon le professeur Professor Heyns, est regardé comme contraire à la mentalité africaine. De plus, la notion de souveraineté joue encore un rôle important sur le continent, souvent comme un écran de protection pour les dirigeants ayant peu de considération pour les droits de l'homme. La création de la Cour n'avait pas prospéré lors de l'écriture de la Charte en 1981. C'est seulement la commission qui a été prévue. Donc, il a fallu attendre 1998 avec l'adoption du protocole de Ouagadougou pour que le projet de créer une Cour africaine des droits de l'homme voie le jour. Cependant, depuis sa création en 1998, la Cour évolue en dents de scie dans une incertitude totale. Avec les différentes réformes dont elle a fait l'objet respectivement en 2008 et en 2014, cette Cour ne cesse de changer de couleur et de configuration à l'image d'un caméléon. Alors, les réformes de la Cour africaine des droits de l'homme et des peuples désignent l'ensemble des mesures et des conventions internationales adoptées par les États africains pour restructurer cette juridiction et réviser ses domaines de compétences. En juillet 2004, pour des raisons d'ordre humain et financier, le sommet de l'Union africaine adopta une résolution relative à la fusion des deux cours, la Cour africaine des droits de l'homme et des peuples d'une part et la Cour de justice de l'Union africaine d'autre part. C'est ainsi que le protocole de Sharm el-Sheikh en Égypte a été adopté en 2008 pour créer la Cour africaine de justice et des droits de l'homme. Un peu plus tard, le protocole de Malabo de 2014 aussi y a apporté une plus-value en élargissant les compétences de cette unique Cour en la matière pénale. Ces deux successives réformes sont tellement préoccupantes pour le devenir de la Cour africaine des droits de l'homme et des peuples que certains auteurs et juges, dont Rafa Benassour, souhaitent que les deux protocoles réformateurs n'entrent jamais en vigueur. Pour présenter l'impact réel et ou potentiel de ces deux réformes respectives sur l'ordre juridique international africain, il serait judicieux d'analyser dans une approche critique leurs implications juridiques dans une première partie et juridictionnelles dans une deuxième partie, pour voir s'ils protègent mieux ou moins les droits humains en Afrique. Quand on prend les incidences normatives des deux réformes, notre première partie, on verra que le protocole de Sharm el-Sheikh et celui de Malabo de 2014 produiraient non seulement un impact important, voire même un impact important sur des normes qui ont été antérieurement établies, mais peut-être sur l'ensemble de l'ordre juridique international africain. Le premier protocole, c'est-à-dire le protocole de 2008, à lui seul a abrogé 3 catégories d'instruments juridiques. Le premier, il a abrogé le protocole de 2008 qui a créé la Cour africaine des droits de l'homme. Ensuite, il a abrogé le protocole de 2003 relatif à la Cour de justice de l'Union africaine, ainsi que les dispositions qui sont contenues dans l'acte constitutif de l'Union africaine en rapport avec la Cour de justice de cette organisation. Donc, le protocole de 2008 a abrogé toutes ces dispositions, toutes ces normes. De l'autre côté, le protocole de Malabo de 2014, quant à lui, a amendé le protocole de 2008 en élargissant la compétence rationnelle et matérielle de cette juridiction à la matière pénale, d'où la pénalisation du droit international africain. Donc, nous verrons tout de suite la confusion qui tourne autour du statut de la Cour africaine de justice et des droits de l'homme avant de voir la pénalisation du droit international africain en grand B. Quand on prend la charte de l'OEA, elle n'avait pas créé une cour de justice parmi ces 4 principales institutions qui sont la Conférence des chefs d'État et de gouvernement, le Conseil des ministres, le Secrétariat général et la Commission de médiation, de conciliation et d'arbitrage. C'est cette commission qui était chargée de trancher les litiges qui opposaient les États membres de l'OEA entre eux. Donc, ils n'avaient pas pensé à mettre en place une cour. Les statuts, la composition et les pouvoirs de cette... il a fallu l'acte constitutif de l'IA, j'allais dire, pour que l'Afrique accepte de créer une cour à l'intérieur de l'organisation continentale qui est devenue désormais l'Union africaine. Les statuts, la composition et les pouvoirs de cette cour étaient définis dans le protocole y afférent adopté en 2003, qu'on appelle le protocole de Maputo. Un an plus tard, et parallèlement, le protocole de Ouagadougou relatif à la Cour africaine des droits de l'homme et des peuples entra en vigueur. Donc, si on reste sur ces 2 perspectives-là, on dira que nous avons un parallélisme de juridiction. D'un côté, nous avons la Cour de l'Union africaine, la Cour de justice de l'Union africaine. D'autre part, nous avons la Cour africaine des droits de l'homme. Et comme je vous l'ai dit tout à l'heure un peu plus haut, ces 2 juridictions à la base parallèle ont été fusionnées. On les a mis ensemble en 2008 au sein du protocole de Charte et Charte adopté en 2008. 2 conséquences vont en résulter. La première, c'est qu'en mettant les 2 juridictions ensemble, on a mis leur domaine de compétences ensemble. Voyez? Donc, la juridiction qui était spécialisée en droits de l'homme s'est retrouvée à l'intérieur d'une juridiction permanente à compétence générale. Ça, c'est la première conséquence. La deuxième conséquence, c'est qu'on a encore prévu une période de transition pour l'entrée en vigueur de la nouvelle Cour. L'entrée en vigueur de la nouvelle Cour, c'est-à-dire que la Cour africaine des droits de l'homme et des peuples va continuer à travailler jusqu'à l'élection des nouveaux juges de la Cour africaine de justice et des droits de l'homme qui a été créée par le protocole de Charte et Charte en 2008. Et les affaires pendantes devant la Cour africaine des droits de l'homme seront tranchées conformément au protocole de 1998. Ces affaires pendantes ne seront pas tranchées sur la base du protocole de 2008. Donc, ça, c'est la deuxième incidence juridique par rapport à l'abrogation de ces textes-là. Voilà, l'instrument juridique abrogé en 2008 et sera appliqué pour les affaires pendantes, même après l'entrée en vigueur du protocole de 2008. Et malheureusement, d'ailleurs, ce protocole a été révisé en 2014 pour élargir le champ de compétences de la Cour africaine de justice et des droits de l'homme aux questions pénales. Maintenant, nous allons voir à ce niveau la pénalisation du droit international africain. Des raisons essentielles ont poussé les États africains à adopter, disons, des mesures et des conventions pour créer, en tout cas, une section pénale à l'intérieur de la Cour africaine de justice et des droits de l'homme. La première raison, c'est le bras de fer qui a opposé l'Union africaine à la Cour pénale internationale dans les différentes affaires qu'elle a lancées contre certains États, certains chefs d'État africains et certaines personnalités. Nous avons à ce niveau l'affaire contre El-Béchir, des poursuites contre El-Béchir, contre le président Uhuru Kenyatta du Kenya, contre le président Hissène Habré à l'époque par la Belgique. L'ensemble de ces affaires-là qui ont été lancées par la Cour pénale internationale et par d'autres États européens, la Belgique, quand on prend l'affaire Hissène Habré, l'Union africaine et les États africains se sont positionnés. La deuxième raison, c'était pour éviter de mettre en place des juridictions pénales ad hoc. À chaque fois qu'un problème se pose, on crée une juridiction spéciale ou une juridiction pénale ad hoc. Donc, ils ont pensé à mettre en place une juridiction pénale permanente à l'intérieur de la Cour africaine de justice et des droits de l'homme. C'est ce qui correspond à la section pénale. Maintenant, cette pénalisation du droit international africain, comment peut-on la définir? La pénalisation du droit international...
Veuillez conclure dans une minute, s'il vous plaît, Monsieur Silla.
Très bien, merci beaucoup. La pénalisation du droit international africain se définit par l'adoption des normes internationales africaines incriminant des comportements et prévoyant des mécanismes de répression de ces incriminations. Et le protocole de 2014 a prévu 14 crimes internationaux et ces crimes internationaux-là vont être jugés par cette seule section. Donc, on se pose des questions par rapport à son efficacité. Pour terminer rapidement sur la deuxième partie, c'est que ces deux protocoles-là, ces deux réformes-là vont produire encore des incidences sur le plan juridictionnel. Ces incidences se résument en deux choses. D'abord, on a transformé toute une cour qui était composée de 11 juges en une section qui est composée de 5 juges seulement. Donc là, au lieu d'avancer, on a reculé. La deuxième conséquence, c'est l'articulation qui pourrait exister entre, d'une part, la section pénale au sein de la Cour africaine de justice et des droits de l'homme et les autres juridictions pénales qui existent avant elle. C'est-à-dire que pour poursuivre les crimes internationaux qui sont prévus par le protocole de 2008, il y a 4 catégories de juridictions qui peuvent être compétentes. D'abord, les États, en mettant en œuvre leurs compétences universelles, surtout l'État territorial ou l'État de nationalité des victimes ou des criminels internationaux. Deuxièmement, la Cour pénale internationale peut mettre sa compétence de complémentarité en œuvre. Et troisièmement, la section pénale africaine elle-même peut être compétente pour poursuivre ces crimes-là. Et quatrièmement, n'importe quel État au monde qui a ratifié le protocole et le statut de Rome pourrait demander à l'autre État qui refuse de poursuivre les criminels internationaux de les extrader en vertu de la maxime auto dedere, auto judicare, ou bien auto judicare, auto dedere. Voyez? Donc, ces deux réformes-là produisent des incidences sur l'ordre juridique africain, tant sur le plan normatif que sur le plan juridictionnel. Je vous remercie de votre attention.
Thank you so much, Mr. Silla. It is wonderful to see emerging scholars also really immersing themselves in the African human rights system, aspects of the court and its reform and its ongoing improvement. So thank you very much for sharing your insights also with us today. I wonder if we have a minute or 5. If there are, I see no specific questions in the questions and answers box, but if there is anyone who wants to raise a question or make a comment at this point, if I can see anyone's hands, I know it is a late hour, but they were such rich and interesting discussions, so I just thought let me allow an opportunity to anyone who wants to respond to or raise any issues. Yolanda, is there any hand that you and the technical team can see? None. That's also fine. I think we are digesting the rich presentation. So it brings us really at the end of our 4 sessions of our conference today devoted to 40 years of the African Charter on Human and People's Rights adopted on 27 June 1981. I can certainly not endeavor to summarize, bring into kind of a cohesive framework the rich discussions of today. But let me just say a few words also about the way forward. First of all, I think the publication in which Christoph contributed, this African Human Rights Law Journal of 2001, was written in the context of reform on the cusp of the Organization of African Unity, the OAU becoming the African Union. We have those transformative moments within the broader context. And certainly now, in a sense, we are 20 years later, and the question about reform is still lurking. As I think many of you know, we have, under President Kagame, seen a very profound, far-reaching institutional reform process being undertaken. And the reform process certainly now is also directing itself at the judicial and quasi-judicial organs of the African Union. And I think it is within this context that we also could contextualize our remarks and reflections. And I think one of the questions that Christoph also posed in the paper that had been referred to is, what form should reform take? What form should reform of the African Charter take? Should it be an amendment to the Charter, or should it be more incremental through interpretive advances, soft law instruments, and so on? And Christoph certainly was advocating broadly the idea that to reopen the debate about a fundamental change and an amendment to the Charter would invite the possibility of a fundamental overhaul that may not be in line with the expectations of those who want to advance human rights. And I think today we've been referred to the forces at play, the trends in terms of which we saw, for example, states withdrawing their declarations or accepting direct access. We have seen trends also towards curbing the kind of naming and shaming possibilities within the reports of the African Court. So I think what Christoph warned us about in 2001 certainly seemed to be more pertinent even today in 2021. I was struck by the presentation of Professor Magliveras, who advanced the argument that perhaps with the coming into being of the African Common Market, we should look at something like Article 2, the non-discrimination clause of the African Charter, and this should be reformed to capture the notion of economic rights that derive from our common membership of the African Common Market. But I think Christoph's counter-argument would be that there seems to be enough scope in a provision like Article 2. There is already the open-ended notion of other status. To open the door, the potential Pandora box of the reform process towards an amendment of the Charter, I think may lead us to, again, pressures on provisions of the Charter that may not be foreseen. So that idea of opening up with consequences that perhaps may not be clearly foreseen from the outset is an aspect that one has to contemplate. So as we move ahead, as there is pressure on the African Union human rights institutions to also conform with the imperatives of the reform, perhaps one should think carefully about revisions to the Charter and ask whether the incremental developments that we've seen have not served us sufficiently. There was also, I think, a very interesting discussion and introduction of the issue of the systemic nature, how perhaps this will certainly be also part of the reform process, how the different institutions working on human rights have integrated their mandates, how do they collaborate, how do they ensure that there is some form of systematization. And I think if this was the question in 2001, then certainly it's a much more pertinent question now, because we have had the court starting really functioning in 2006, the Committee on the Rights of the Child starting to function from 2002, and we've seen a plethora of other human rights linked institutions, organs being created, from the Pan-African Parliament to the Economic, Social, Cultural Council to the African Union Board for Anti-Corruption. So I think that will certainly be another imperative that will be informing this reform process. And our first speaker, I think Mr. Zuapet mentioned, for example, the interrelationship of the regional economic communities, the ECOWAS court in particular. If we consider the amount of decisions that the ECOWAS court has given already in which violations of the African Charter had been found, this certainly must be an element that needs to be taken very seriously. How does that correlate in a context where there will be an ever closer integration of the regional economic communities within the African Union? So that's another avenue, I think, that was interestingly opened up for further discussion. In that context, I think the role of the court as opposed to the commission and their complementarity, that has been a recurring theme in a number of presentations. One expression of the way future was that perhaps the African Commission would be better placed to be devoted exclusively to promotional work, whereas the court would then be the institution to deal with protective work. That may be an avenue to explore on the longer term. Maybe I just state that at least for the short term, it seems to me that that is not on the cards, because at the very least, in terms of the pragmatic concerns, we only have 6 states that accept direct access to the court. Of the 54 state parties, 30 have accepted the court's jurisdiction. So the other 24 that have accepted the jurisdiction of the court, for those, individuals still have to go to the commission first. So that is the institutional landscape, and one cannot wish that away. And for the 24 that have not ratified the court protocol, clearly there is no option of the court there as well. So they have as the only port of call for violations against an individual in any of those 24 states would be the commission. So yes, we can think about how the system may evolve over time, but for the moment, I think the reform that is ongoing at the moment would have to take into account those realities in terms of access and institutional linkages. There are many more issues to discuss, but I think that we will find opportunities to read the full papers of all the presenters that had presented their thoughts today in due course. I would like then at this point also to just talk give some brief remarks about the way forward for this particular project, as it were, from this conference onward. We have received papers of most of our presenters, but we will now give an opportunity to each of them and those who perhaps had still been having work in progress to complete and submit to us. We'll obviously communicate to the authors by the 31st of July. So that's the idea, that these papers will now undergo peer review towards being potentially published in the last issue of the African Human Rights Law Journal. So to mention the obvious, the issue that we're referring to came out in the first year that the African Human Rights Law Journal was launched, 2001. So it is also 20 years, it is the 20 years birthday, if you like, birth year of the African Human Rights Law Journal. And the publication that will then come out in November, December will in a sense be both a celebration of the 20 years of the journal and then this conference, which looked into the 40 years of the African human rights system based on the African Charter having been in place. So there's a certain harmony about the 20s and the 40s as we note them in both the African Human Rights Law Report, Law Journal, and in the history of the Charter. We wish then to direct a few words of thanks at this moment, this late time here, at least in South Africa on a Friday afternoon, but wherever you are, first of all, to our participants, thank you. I think we were more than 120. The numbers have dwindled and been up and down. We thank you for your time. We realize that there are many demands on everyone's time in this virtual world. We appreciate your attendance virtually and your participation, in the sense that I'm sure all of you took note and were happy to also make comments and questions. And we have Commissioner Fardel who was called upon, but unfortunately at that point we could not have your voice, but I see that she just puts in the chat box also. Thank you very much to all the panelists and to the organizers, and we really appreciate you also being here, Commissioner Maya Fadel from the African Commission on Human People's Rights, that we appreciate your participation and all other participants. Then to the presenters, I really honestly feel that we have a very rich African Human Rights Law Journal coming up. We have listened to just snippets, the surface arguments of our presenters' papers. They will now rework, finalize after the review process, and these will be published. Thank you very much for your having gone through this whole process and for the future finalization of these papers. To our chairs who helped us, assisted us in keeping the day going, in prodding the presenters here and there, we appreciate your contributions to the smooth running of today's event as well. I must thank one presenter who happens to also have been the driving force, the one who held the reins on our side in the center, and that is Professor Magnus Schilander. Magnus, thank you very much. Magnus was the one who communicated with our presenters and kept the whole system afloat from our side. Thank you very, very much, colleague, for that. If it's a technical event like this, virtual presentations taking place, there obviously always is a team behind the scenes that makes it smooth, or make it running smoothly, even though there may be some difficulties from time to time at our side from the center. I just want to thank Yolanda and Taruna. I think they are the two on duty at this late hour. For most people in South Africa would have taken the weekend in their stride already. We thank you very, very, very much for your dedication beyond the call of duty to making the professional virtual presentations possible that we've seen today. We thank our two partners, the African Commission on Human and People's Rights and the African Court on Human and People's Rights. We're not excluding the committee for any particular reason, but obviously the focus here is on the African Charter, and the principal organs that are there to monitor would be the African Commission and the African Court. We obviously recognize the important role that the Committee on the Rights of the Child play, but it is based obviously on another treaty framework, that of the African Charter on the Rights and Welfare of the Child. Lastly, I want to thank, remember, honor, acknowledge Professor Christoph Heyns, our colleague. He has passed, but I think he was very present here today. From the first presenters throughout the day, we heard his name being invoked, people making reference to personal engagement and interactions with him, or referring to his particular seminal article, the one in the 2001 African Human Rights Law Journal, or other publications. I think Christoph would have been so happy to know that the debate about reform is ongoing, and that he was part of the legacy of informing this. I can do no better than just cite a few of his words as we conclude our event. In that article towards the end, he wrote the following: "The debate on the possible reform of the system in itself is already an important contribution towards the improvement of the system. Engaging in this debate is to exercise a form of ownership, and to say that since the Charter belongs to all of us, to continuously ensure its improvement." So I think that sums up Christoph. He was expansive and inclusive in everything he did. His us outreach, his sense of collective responsibility, collective ownership of the Charter. And I think we can do no better than to be informed by his legacy in our collective endeavor to take the work of the African human rights system, the African Charter, forward. And I have one last prop. And this is, I think many of us who know Christoph also knows that there was great joy for him in sharing and being expansive. And in those days when you know, the internet access to the documents around the African human rights system was certainly not so easily accessible. He was at the forefront of bringing these documents together and making sure that a much broader audience, a much greater public would have access to and would start to be interested and engaged in this. And I think the scholarship that has engaged scholars since 2000, increasingly, it's also informed by this kind of impetus, this making sources available. And on this in this magnus opus called Human Rights Law in Africa, Professor Heyns, editor, we see the image here of a lighthouse. And this lighthouse is a painting, a picture that Nelson Mandela himself drew while he was in Robben Island. And in fact, I'm here in the office. If I could show you the painting on the wall, it's here on the wall. And it was put on the wall here at the time when Christoph occupied this office. So I show this to perhaps in the final moments for us being together, we can take that image of the lighthouse that was so important to Christoph to also put on this magnus opus of works and documents from the African system, that we have that image in our minds, that we will be informed to work you know, towards a goal, the common goal that we have. And thank you so much for everyone and who contributed today to better inform us. And we promise that the issue of the journal will come out in December, and hopefully it will be something that all of us will be able to use and take together. So I wish you all the best with our collective endeavor of improving and sharpening and strengthening the African human rights system. Thank you for your participation. Good afternoon.